Have gained so much weight.
That's the side effect of
Yeah. You can listen to the eras. Sorry, I muted myself. There we are. I'll start the introduction again. Ladies and gentlemen, friends, very good afternoon. Ordinarily, we don't do webinars on a Monday. We usually do it on a Thursday. But today is a very special occasion because my dear friend Winston is here from Singapore in Kuala Lumpur. That is why we're doing this webinar from the lounge to show to our friends that our borders is opening up and Malaysia is opening up to the rest of the world. Good sign. And I guess we are moving away from this COVID pandemic in our own way in Malaysia. And therefore, since he's here on a Monday, and it's not very easy to get Singaporeans to come and spend their time in Malaysia. So since I got hold of him on a Monday, we thought we will do this webinar today. It is a topic that is not has not been discussed much in Malaysia because we don't really pay much attention to it. It is something that we could explore because Malaysia has taken up, Malaysians have taken up these treaties in some parts of the world. I'm aware of a client of ours in the oil and gas industry who has done this in Indonesia and so on. So today's session is essentially a dialogue between myself and Winston. So let me give a short introduction of Winston. Winston is a partner with the Singapore law firm KhattarWong, which is part of the Bidders Worldwide Group. Bidders is one of the oldest and one of the largest law firms in England. And KhattarWong has become part of Bidders, what, 5 years ago, I guess?
6 years.
6 years ago. 6 years ago. So Winston is very Malaysian like us. We don't talk about work after working hours. We just, do other things that we're supposed to do in Malaysia, which is makan and jalan-jalan, So on that note, I thought I will ask Winston, before we go to the topic, to first say to Winston, welcome to Malaysia.
Thank you very much.
And how was your entry to the Malaysia today?
Actually, it's quite smooth, to be honest. It's quite smooth.
Yeah.
I think they changed the rule a little bit. So now when you get off the plane, you do your PCR test, and then you can leave the airport and just go straight.
And you're here straight from there, lah?
No.
All right, went to the hotel.
You go to hotel.
Right.
We still are considered a person under surveillance.
I see.
So this morning, then we got it cleared. So now we are free to move around.
And you got a MySejahtera downloaded.
Yeah, have to.
Okay. So ladies and gentlemen, that shows that we are now can all travel, receive visitors, and that's now my chance to do my travel plans accordingly, I guess.
My suggestion: go after first April.
To skip the quarantine.
Skip all these things.
Yes, all these things. So Winston, the reason how we came up with this topic, we talk about investment treaty disputes, sometimes most places know the bilateral treaty, right? It is because I have read that we just did a fairly large case involving the Nigerian government, going against the Nigerian government for one of our clients. Could we start the discussion today with that case?
I think it's a good way to start because one of the reasons why we're talking about this is, like you said earlier on, we discovered that most of our clients and investors generally do not really know much about investment treaty protection. So especially when we did this case for our clients, which is actually a Chinese party. So I mean, I guess things are sometimes easier when I illustrate it with a story. So I'll tell you a bit about this case. So what happened is this Chinese company, they entered into a joint venture with a Nigerian state company to do a joint venture to develop a free trade zone in Nigeria. It's about 10,000 hectares. So the Chinese party had 60%, Nigeria had 40%. The Nigerian government also gave certain concessions. So Chinese party also set up a subsidiary there to run, and under the joint venture agreement, the Chinese parties were appointed managers of that project. 4 years down the road, the Nigerian government decided to terminate the contract and just walk away from it.
No compensation.
No compensation. So obviously, when the Chinese party was left in the lurch, their immediate recourse was to sue the Nigerian party through the joint venture agreement, because that's where the appointment and the rights arise. So they sued under the joint venture agreement. The joint venture agreement provided for arbitration, the seat of which was in Singapore. But the Nigerian government were quite crafty. They went to Nigerian court. They got a court order to injunct and to prevent the Nigerian party from participating in arbitration. So in our colloquial term, jam.
Right.
So then basically the Chinese party had no recourse. So about 2 years after they commenced arbitration in Singapore, we met up with them and we looked at their case and we told them that, look, you actually can consider going after the Nigerian government because there is a treaty between China and Nigeria, right? And under that treaty, they're supposed to be treated fairly and equitably, in which case they were not. So the arbitration was in Washington, we were successful, and the clients were given 70 million compensation. The 70 million is not just for the expense and cost that our clients incurred in investing in this project. They also factored in 20 years of profit as part of the compensation as well.
Right.
And I mean, the Nigerian, they also compensated a bit of pain and suffering, because what the Nigerians did was, when they terminated the contract, they sort of used the police and they used some of their people, their staff, to threaten some of the Chinese employees that were in Nigeria, get them evicted out of the premises and stuff like that. So they did one or two nasty little things. But generally, yeah, it was quite a success for us.
Some gangster approach as well.
Yeah, big thing there.
So, but friends who are joining this webinar, I must highlight to you, this treaty is different from the usual double taxation treaty agreement that we have. This bilateral treaty is different from investment treaty. Yeah. So Malaysia, because I also must always talk about Malaysia when I get a chance now. Malaysia has about 70 over treaties as well, over and above the DTAs. Where specifically it's country-to-country treaty where Malaysia also has agreed to honor what we call investments made by those member countries in Malaysia. So if I may share one Malaysian experience, I read the popular case, I guess, is a case where Malaysian government entered into a contract with this foreign company, where their business is to go and look for shipwrecks along Malacca Straits. And we all know Malacca Strait is the busiest strait in the world, and a lot of shipwrecks. And they said they will invest time in this particular period. We will look for the wreckage, and if we find anything that is valuable, it will be auctioned off, and parties agree to share it. The Malaysian government and the company, the private company. Of course, we know all this treasure, we find it belongs to the government, right? Now, they couldn't find anything within this stipulated time. So there was extension of time given to the private entity to look for it. Eventually, they found a shipwreck, and then they went ahead and found some let me see from which era it was. The name of the case is Malaysian Historical Salvers against Malaysia. That is the name of the case. And they went and what happened was filed. The dispute was with regard to the value of the auction, and they fought, and this matter went before the arbitration. A Singaporean was appointed as the sole arbitrator. His name is Michael Huang, senior counsel. So he was the arbitrator, and I'm sure he's a very nice arbitrator because he ruled in favor of Malaysia. So the Malaysian government argued, that this particular venture is not an investment.
Right.
Because to benefit from the treaty, the aggrieved party must show that there is investment. And then first part. Second part, it must show there's a breach of the representation made or expectation by the Malaysian government, and then he was not given due compensation. These two elements are satisfied, then of course you are entitled to get compensation. So here the arbitrator ruled that the burden to prove that there was an investment is on the aggrieved party. And that company failed to show that they had an investment within the term envisaged in the treaty. And because it was not an approved project. So friends, you are joining us today. A few terms you got to pick up in this treaty. You need to have investment, and the investment is an approved project, and there must be a termination of the approved project without you being given proper compensation. So it's not that the government cannot compensate and cannot terminate. It can, but they must compensate you for all your losses. So in the Nigerian example, there were no, so there was actually an investment, approved investment, I guess, but and the compensation was not given. Hence why the Chinese were aggrieved.
Correct.
Yeah.
So the Chinese cannot go under. They got stuck because when they actually went under the joint venture agreement, right? The Nigerian government actually got a court order to prevent them from proceeding. So the only way around it is to actually go
after Right. I think the treaty is quite nice. If you master it nicely, going after the government is always nicer.
Yes. And it's effective.
Effective, isn't it? Yeah.
It's effective because once you have an award, then what you do is you actually go after the government's assets wherever they are in the world.
Yeah.
So actually, again, like I said, the best way to illustrate is through another story. This one, very famous character. So it is about enforcement. So for those who go to Bangkok, not the new airport, the old Dong Nang Airport.
Right.
There is a highway between Dong Nang Airport and Bangkok. So that highway was actually built by a joint venture between the Thais and the German company.
Right.
And that is under the Thai government concession. So after that highway was built, they started collecting toll, right? But the toll was not sufficient because it was a lot built, and through time, under the concession, they were supposed to adjust the toll rates. But the adjustment under the terms of the contract, under the concession, was subject to the Thai government's approval.
Right.
So despite a lot of presentations as to the cost, that they are losing money, they're doing all sorts of things, and it's not reasonable, the Thai government just simply refused to allow them to increase the toll rates.
Right.
And that's probably one of the reasons why the German company also went under. So anyway, the German company then took action against the Thai government.
Right.
Same thing, under the investment treaty, to be treated fairly and equitably.
Right.
The arbitration tribunal found that the Thai government was not treating the German company fairly and equitably. So the Thai government, an award was given against the Thai government for 30 million euros.
Right.
So the Thai government, despite having an order against them, refused to pay. And what I understand was that the government said, look, you come and get me lah if you can. So the German was very patient. They waited for quite some time. And the one fine day, I don't know whether you're aware, but there's been news about this. The now King of Thailand, then Crown Prince of Thailand, he used to go for his holidays in Germany.
Yes.
Correct. It's a well-known fact.
He still does.
Yes, much to the distress of the German government. But so his 737 Boeing landed in Munich. The moment the plane landed, they arrested the vessel. They arrested the aircraft. Yeah, the aircraft. They arrested the aircraft. So the Thai government protested. Thai government said that no. You cannot arrest this. This is not his plane. It is his plane. It's not the Thai government plane.
Right.
It's not an Air Force plane or whatever.
Right.
It is the Crown Prince personal plane.
Right.
So they went to the German court. The German court said, look, I cannot make a decision here now. It will take some time. It's an entire hearing, isn't it? Of course, the Crown Prince don't have the kind of patience. So under the, I guess the government also under a lot of stress and pressure, the Thai government actually put up a letter of guarantee to the German court for, I think, more than 30 million, maybe about 30 over 40 million euros as security to release the plane.
Right.
Yeah. So that is just to illustrate to you that it is effective. Like if you can find assets to attach or to try to go after, it's quite effective.
Malaysia was also in the news lately because of fellas claiming from Sulu royal family got an arbitration award against the Malaysian government.
Yeah.
So it became, of course, the Malaysian Attorney General has issued a statement to say that the claim has no basis, but still it generated the publicity that the other side wanted,
So going back to the point that you're bringing up, this investment treaty is different from the double tax treaty.
Yes.
So I guess the other thing that we wanted to tell investors, people who invest overseas, that whenever you invest overseas, most of the time everybody will go to their tax lawyer, their accountant, to come up with the best tax plan, to find the place that they friendliest in terms of tax. Look at a double tax treaty. We are just saying that look, if you are investing in big infrastructural projects, especially, you should not just look at tax. You should also look for this investment
treaty and see how it helps you.
So you find a jurisdiction that gives you the best of both.
Right. And on that note, Malaysian companies have also made use of these treaties, Winston. MTD, a well-known Malaysian development company, construction and infrastructure company, successfully got an award against the Chilean Republic for breach of contract. This is way back in 2004, where when the Chilean government decided to change its mind when it comes to certain project after they've invested in Santiago, and this is all about the rezoning of the areas. Was not done as was planned. So approval was given, but later, once they had spent their money invested in that country, they were then told that the project was inconsistent with the government, the Chilean government's policies at the time, and that resulted in them going to court and getting compensation.
Right.
The other one is Axiata that took the Nepali government to arbitration as well, but I've read here details show that the terms are confidential. Ekran has also gone against the Chinese government in China. This is about the construction of a facility in China. Again, the dispute has been resolved.
Right.
So it shows that Malaysian companies have utilized these treaties. And I said, I'm aware of a Malaysian oil and gas entity that has gone to Indonesia when there were some issues with the Indonesian government as well. So I guess this is another foray for investors to keep an eye, because if you are entering into like the Nigerian example, if you're entering into an agreement with company A, which could be state-owned, because very rarely state do the project with it directly, right? State will have its own SPVs.
Yes.
And they want to ring-fence it. So if you sue them in court, you end up suing an SPV. And if you go to certain jurisdictions where rule of law can be applied not in this true sense, and the court decides to find ways to assist the SPV, then you're stuck. And or it gets protected for a very long time. and that's where going after the state is quite effective. But when it comes to enforcement, so assuming I get the award, say like the Thai example, I got an award against the Thai government, and they don't pay me. Is this like your normal arbitration awards? Can it be enforced? Yeah.
Yes. So the New York Convention kind of arbitration award and personal arbitration will also apply. So if some of your signatories to it,
Right.
you can definitely apply.
Right. And has anyone taken the Singapore government to task under this treaty?
Actually, we did a check. I don't think we have, fortunately. Either that or our ministry is not showing it on their website. we did a check as to whether they went.
I also like, because you go to the UN, and you can check. You
can see all.
You can check all the ongoing disputes.
Correct.
How many treaties each country has signed up to.
Right.
So it's quite impressive because the data.
I mean, Malaysia is very impressive. That 70 over treaties.
70 over treaties in Malaysia. Yeah.
Actually, Malaysia, Singapore, got like 40 over treaties.
Right.
I mean, it depends. Some are bilateral, some are multilateral. So
that is because I guess, Winston, Singapore has always been a investment friendly jurisdiction, and I guess you have politicians and civil servants who understand that mindset and they are pro-business that way. While in developing countries, sometimes civil servants get overzealous when you look at that. In fact, I had a case here in Malaysia. I will not mention the taxpayer's name. Ongoing case in court. They invested 1.5 billion ringgit on an approved project by MIDA, which is the Malaysian Investment Development Authority, to build a chemical plant in Malaysia, and they were given a tax incentive for product A. And while product A was going on, they want to do product B, so they also asked for another round of incentive. They were approved,
right?
But they were building the structure for this product B, and they were claiming the incentive for product A as they were going on. And every 6 months, MIDA comes and visits them and says, all right, everything's on progress, very good, you invested the money. Because MIDA, when they give you the approval, they will make it very clear. You must invest X dollars by this date. You must employ so many Malaysians, so many people in this particular category. You don't put Malaysians to all the menial work, in the technical and skill work. They make it very clear. Sometimes they even can see a number of Bumiputras in management role and things like that. So MIDA checked all that, and the clients ticked all the boxes. Where they couldn't, they asked for an extension of time and grace period, duly granted.
Right.
MIDA, in that regard, well, give them credit, they're very pro-business. So they understand the circumstances. But in 2019, Income Tax Department in Malaysia comes and audits them and tells them, this particular incentive is not, this condition is not met. I'm going to full back these incentives, and I'm going to ask you to pay tax. And they will tax for about 420 something million ringgit, $100 million. So a lot of money.
It's a lot of taxes.
And but under the law, the revenue treats as if you don't have this incentive, and as if it is withdrawn. They say we never withdraw it, but the effect is as if it is withdrawn, right? They give me a tax free. I'm supposed to be tax free for so many years. And we filed the judicial review. We got a stay order in court first. And one of the options that I had in mind when I briefed the client was to go after the Malaysian government for breach of the treaty as well. Because you approved this project. It's an investment we have made. We tick the box. Project approved because you've given me an approval letter and it's an approved project. In fact, it's in the statute as well as the approved project. And then you come and tell me that I'm not entitled to this. You can't do that. And the entity that came and told me this, although it's illegal report, that's where I stopped, because I wanted to say it's part of the government because it's still a government agency like your IRAS, right? So, but because it is a stay order, we were not in any particular rush. It was a plan B option, and I'm pleased to inform that they just 2019, 2020 January went to court. Just a few weeks ago, the government has agreed to resolve the matter, and the client is coming to settlement. Will only pay probably less than $2 million as taxes, compared to $100 million dispute. So that avenue is also an option that I considered at the time. So it's very good, especially when you get investment treaties that are approved. So I guess the message to our clients who are hearing, joining us today is that when you go and do these investments, when you find your target country, many Malaysian companies are going to Burma, Myanmar to invest, Cambodia, Vietnam. In fact, you go there, you see many Malaysians in this part of the world, right? I think we've gone to Cambodia before. Many Singaporeans went there, you know, and if you have, as you go and check for tax law, tick the boxes, as you go and tick for all local laws, also put a box on investment treaty protections, because it can come and help you later if you get into a problem. Because if you get into a tax dispute and all that, you only can dispute it in the local courts. And if the local laws are not favorable to you as an aggrieved person because you're going against the government agency, that's where the treaty comes handy. Yeah, that's a good tip for us to consider, especially Malaysian entities that are going to invest. And I guess in that case, you see, Winston, Malaysian law firms, we are still a very close legal practice here. So foreigners are not allowed to practice in Malaysia, except in very limited circumstances. You're known as a foreign lawyer, and they can't appear in court, and they can do certain nature of certain work. I think, if I'm not mistaken, I can recall 2 foreign law firms that were given license to practice as foreign lawyers in Malaysia. The UK law firms in Malaysia, and but Vidas, on the other hand, you're based all over the world.
We're based in Asia, Europe, and US. In Asia, only we have 3 offices: Singapore, Hong Kong, and Tokyo.
Right. And what do you call in Europe? I've been to your London office. So for Malaysians, businesses that intending to go to certain jurisdictions, especially where your presence are there, it'll be easier for them to make use of the services as well. Sure. And perhaps I can open the floor for some questions first, because I want to make it very interactive. And friends, you got any questions on disputes, including questions asked about the Singapore environment, they're most welcome to ask Winston. As you can see from the way he interacts, it's very Malaysian. I don't hear him using the laugh so much, but I'm sure you realize in his demeanor and his approach is very casual. So don't feel shy to ask questions. I see a question. I see enforcement as a challenge, even if there is a favorable award. How do you overcome this, considering the process and procedures of the local courts?
Yeah. So as I said just now, as an example, right? If it goes back to the local courts, it would cause a challenge. But most countries do have investments and assets outside of their countries, so those assets are all up for grabs.
Yeah. And this anonymous entity didn't give his name, him or her. My friend, remember when you go to treaty, you end up going for arbitration eventually, isn't it?
Right.
Arbitration cost awards are very high if you win.
Yes.
Yeah, you can recover back your costs, you see, to a large amount of your cost. Unlike our Kuala Lumpur local courts, our local courts here, our costs are very low. It's 5,000 ringgit, 10,000 ringgit. Of course, no right-thinking lawyers would act for you for 5,000 ringgit, 10,000 ringgit, but that's the cost you get. So that could be the reason why this participant have asked this question. But just let me assure you, arbitration awards costs are much higher.
Yeah, and to be frank, for this kind of disputes, right? Usually it's most of the local firms, even like Singapore, we do not handle this. A lot of, even for us, all this is handled from our London office. We have a team that specializes in this. there is litigation funding that sometimes could be tapped on. So there have been instances where it's kind of, for this type of arbitration cases, if they have a pretty strong case for for it to be litigation funded.
Right. And I got another question here. Is there any avenue for protection for US entity investment into Malaysia, enjoying tax incentive, although there is no tax treaty between Malaysia and the US? Let me just do a quick check as I look for the answer. Whether Malaysia doesn't have a DTA with the US, but I just want to be very sure whether we have. So we have a limited DTA with the US, but I'm not very sure whether we have a bilateral treaty. But let me just check that for you. While I check that, there's another question here sent to me. The question to me here is what we call can bilateral treaty be used for private disputes?
Yeah,
that's the question.
Yeah.
Yeah,
it must be where the government
is involved.
Yeah. So if the government has done something that, because the government is giving the assurance in the bilateral treaty that you'll be fairly and equitably treated, right? And also, like, for example, you will not get your assets will not be expropriated. So it doesn't mean that it's only contracts between the individual and the government. It could be like in the case of the Thai government. It is actually, it's the only thing they're going after is just a concession.
Yes.
There are also disputes where it's private parties with local companies there, these private companies setting up businesses, and because the government has changed the circumstances such that it makes it possible. So it's not the local partner who's giving you a problem, and the local partner is not even linked to the government, but it's because the government created circumstances such that you're unfairly or it's unfair for you. So
right.
In that case, you can still go ahead.
Yeah. To answer the earlier participant's question, I just Googled. Google has all the answers, right? So the UN's website shows there is a trade and investment agreement between Malaysia and the US. Yeah. So there is an investment treaty agreement, not a double taxation agreement per se, but investment treaty with all treaty investment provisions in force since 10th of May 2004. So technically, there is one for this kind of treaty.
Yep.
So you could actually use it. So a US company is not getting proper investments in Malaysia, or is being taken advantage of by the government agency unfairly, especially by the Inland Revenue. We are the only one doing this. See, the question is very specific. It's a tax incentive. Because MIDA won't do this to you. The tax department does that to you. So I think there is revenue to pursue,
But you have to be, for every case, you must look at the treaty itself, because you have to look at how wide or how narrow the scope of the treaty. So if the treaty is drafted in such a way that it's quite narrow, then you may not get the protection that you're expecting. Yeah.
Yes.
So you have to be very careful as to what exactly was agreed between the governments.
And the other thing is, in Malaysia tax law, I don't know about Singapore tax law. In Malaysia, you pay first, stop later, 30 days. You got to pay your taxes within 30 days. And if you don't pay within 30 days, there's a 10% penalty.
Oh, okay.
Right? So 100 million ringgit tax will become 110 million ringgit on the 31st day. If you don't pay, then you go after the company and the directors, if the directors own 20% shares or more. So therefore, because bilateral treaties won't take effect so quickly, so the question is, you then end up doing a judicial review, get a stay order.
Right.
So for participants, assuming a bilateral treaty can be applied, then you may want to do two approaches, right? One, to get a quick remedy first, which is to get your
Stay order.
Your stay order in Malaysia,
Right.
And then you commence your treaty dispute and the seat that you want to choose. Example, depending on the arbitration rules you want to apply,
Yes.
then you choose the appropriate seat. You won't be in Malaysia,
Yeah.
so it'll be heard, probably the UK or Paris,
UK or US.
neutral.
Usually it'll be in the International Center for Settlement of Investment Disputes. So there is a center for it, and it has like over 150 countries signing up.
Yes.
So a lot of treaties. Again, you have to look at the treaty where it's the ICJ.
Yes.
So you have to look specifically at the treaty
Yeah.
they're applying on.
So Marshan, Marshan Singh has asked.
So
What
that's
which
my
forums
yeah.
are usually
So
here?
yeah, I said it's usually the International Center for Settlement of Investment Disputes. Yeah, it's in Washington.
Yeah, that's where most disputes take place. Yeah. There's a question from Grace Ng. Grace, can Saravana share with us a Malaysian case for treaty shopping point, please? Malaysia doesn't have what you call anti-abuse provision per se for treaties. Where you go choose treaties. We don't have specific laws in this part of the world. But Malaysian revenue generally will, if they want to use it, they use anti-avoidance. But there are no reported cases, Grace, or treaty shopping or someone being targeted for abusing tax treaties in Malaysia. We have not gone to the stage yet. But I remember a couple of years ago, there was a case in Indonesia where the Indonesian government went after a Dutch company for abusing the treaty. Because the Dutch and the Indonesians have a very favorable treaty because of the former colonial past. And this company was accused of taking advantage of the provision, treaty shopping, just to get an advantage over that. And that was seen as a tax abuse. But in Malaysia, no, Greece. So far, no. I don't see that.
On the point of treaty shopping, I think there's a distinction between, or there's a difference in terms of, I guess, tax and for investment treaty. For tax, right, you probably, if you're going to rely on the treaty, then you must have some degree of presidency, or you must have some presence of business in that country.
Yeah, substance.
Right?
Yeah.
Substance. Whereas for investment treaty, the threshold is much lower.
Yeah.
Sometimes just the pure fact that you're incorporated there, that's good.
Yes.
So again, it depends on. There are instances where the treaty actually specify additional conditions. Right. Most of it, as long as you're incorporated in a country, enough. So if you want to make it work for both investment and tax, then you probably need to have some substance in the country that you wish to set up.
And that is because, friends, if you remember, the purpose of double taxation treaty is to provide relief from double taxation. It is a treaty to give relief from tax. While bilateral investment treaty is specific, the purpose is to help you when you get into a dispute with the state, right? So that's why the focus is different and the thresholds are different. So I think the BIT is more enabling for you to commence an action. Another question here: what is the procedure for tax-related disputes in relation to investment treaty protection? See, of course, from a Malaysian experience, if I may start the answer, it would be, I think you must still go to domestic court and get your remedy first, because you cannot ignore that remedy. It's like having a wound. You must get the first aid done first, right? Before you go and see the specialist. So going to local court to get a stay order or filing an appeal will be the first basic things you do to make sure the wound, it doesn't bleed, so you're still alive by the time you go to see a specialist. Then you can go and see how the treaty applies to you. But you see, your question is very general because, as Winston pointed out, it differs from treaty to treaty. You got to study that and see how a tax dispute can fall within the bilateral investment treaty. Because I guess it is as an investor, if the tax treaty is the reason, the tax incentive is the reason why we invested in the first place in part of the world, and then that investment is removed from you, could that be the breach of the expectation promised to you, isn't it?
Yes, that's it. So if the earlier cases that I was telling you, usually what you're going after the government for is because of the expectation. You're given a concession, you're going to build something. You're given certain rights, you're going to commit to certain things. And then suddenly the government say, oh no, you're not going to do this anymore. Or they created circumstances that frustrate that. And that's where you go after. So I would think, like you earlier on, what you said is that in the case that you're talking about, I would think that if even if it's a tax thing, it could fall under investment treaty.
The expectation concept that Winston is referring to is what we lawyers call legitimate expectation. A process of law in this part of the world, and jurisprudence recognizes that. In fact, those who've been following my webinars and my social media will know, in January we won a case, the first case in kind in Malaysia. A client invested into a power plant, so spent billions of ringgit to build a power plant in the state of Sarawak. And they were given an incentive, tax incentive, called investment allowance, which allows them to claim against the income that they will make from the project. And if you can't utilize the amount every year, you can carry forward indefinitely.
Okay.
Right. And when my clients did the construction of the power plant, and when they did the projections of, power plant takes time, right?
Yeah.
The gestation period is quite long, but they say they need about 24 years to utilize all these incentives.
Okay.
Because the entire amount you invest on the plant is given back to you as investment allowance by the government.
Yes.
Okay. So clients were happy. They started the project, and the project was nearing completion. Of course, Malaysia had the change of government since the last time I met you. 1, 2, 3 different governments. So very colorful. So the incentive was given to them by the Barisan National Government.
Right.
Okay, this is before 2018.
Okay. Pre-COVID.
Pre-COVID. Then then after that, the government changed. Pakatan Harapan government came, and the Pakatan Harapan government decided that you're going to get incentive allowance. You'll be given 7 years to utilize. After that, it's burnt. So client then writes to the finance minister from Pakatan Harapan then and says, listen, I got this. I need 24 years. I can't do this in 7 years, right? Because my project is a big project.
Yeah.
It's a Hulu place in Sarawak. So I need time, right, to do all this. Minister replies, one-liner, okay, your application is rejected. Okay. So this style of giving rejection in one line without reason is not only to be blamed, to be fair to Barisan National, Pakatan Harapan also does the same, right? So if in Singapore one day we have a change of government and they think a lot of things will change, believe me, I don't think so. Right? So they gave this answer. So when they gave this answer, your application is rejected.
Right.
We filed a judicial review against the finance minister in court, and to say that the minister has acted wrongly. I got legitimate expectation that I can claim this indefinitely, right, because at the time the approval was given, the law was indefinite. So the concept of vested rights in me. Of course, by the time the case was heard, when first went for hearing, the Perikatan national government came into power, right? So Barisan, Pakatan rejected, came to Perikatan National. So the case started in court during the Perikatan national government, and decision delivered now during Perikatan Barisan National Government, right? So I had the benefit of appearing on this matter under 4 different governments, right? And the court ruled that the minister was wrong to say that the 7-year rule applies. So the court accepted our argument that at the time you made the investment, you embarked on the project, you relied on the assurance of the approval of the minister, which the law was indefinite until you utilize every single dollar of that. To now suddenly go changing is not fair on you.
Right.
You can impose a 7-year rule much later. I mean, for new investments, but old investments you can't do that, because when I know 7-year rule, I may not invest in this project, right? So the court accepted that argument. Then next argument court said was, minister also cannot make decision in one line to say I will not approve. No, minister must give reasons, and when minister doesn't give reasons, court accepted my argument that the petfield inference will be inferred. The petfield inference is the English test that says that if a minister is unable to give a reason for his decision, the court will infer that he has no good reasons to give. Hence why you couldn't name a reason. So that's how we went after the former finance minister in this case, and we succeeded. Of course, the government has appealed to Court of Appeal on this. But the point here is legitimate expectation is a concept that our courts have also recognized in administrative law and so on. Another question here, in your personal experience, do you find Malaysian and Singaporean companies to be familiar and knowledgeable with the bilateral investment treaty protections or investment structuring? Petronas, for example, is quite savvy user of investment arbitration with recent case against Sudan. But does that, in your experience views, reflect the wider market?
Actually, no. That's probably why we have this discussion. That's why we're having this seminar here, because we discovered that there are a lot of people who are not aware of this avenue, and usually most parties will look to their contract, their own private contract with their counterparties, and they'll sue on the contract. And if it doesn't work, then tough luck, and then it's a write-off. So yes, that's why we are looking at at least having seminars and just reminding people that there is another avenue to look at. Yeah.
And of course, we are very fortunate. Petronas is very well managed, and being the only Malaysian company on the Fortune 500 list, they are savvy. They know about these, and I guess this is how it should be when you go to invest in any jurisdiction. You must have a checklist, and the checklist must not only be from the operational side.
Right.
You must also look at legal aspects, tax aspects, and protections from them. And sometimes private entrepreneurs, investors get so excited about the project, and they only think of the good things in the project.
For the profits to be achieved.
Yes, and forgetting that you will have these issues. And of course, the countries you get these issues are, as I said earlier, developing countries.
Where there's a high risk, high return kind of.
Yes, and the government change, or the government, rules by decree, or you don't see someone taking the US government or the UK government to court for disputes, or the Singaporean government for disputes, because first, they are all investment friendly jurisdiction. Right. Number two, you also don't go and invest in US and opening up a factory there. If any, you're going to go to a developing country and open up a factory, and that's where the issues start. Yeah, because you will have politicians who may do it differently, and that's where you got to know your rights.
I guess I mean, like I said, why we're having this seminar is because if you look at big state-owned enterprises, or huge MNCs or companies like Petronas, obviously they have a team of lawyers working with local and foreign international lawyers, so they're quite savvy and they're quite aware of all these things. But what I think we are trying to spread the word is more to the SMEs, and mind you, today's SME is not small. Even the SMEs, they are looking at investing overseas, anything like 50 million, 100 million price tag. That's the kind of investment they're putting. And like you said, originally in the past, people started investing in Southeast Asian countries. Slowly they go to China, now they go to Vietnam, now they go to Myanmar. Next, they're probably going to Africa and things like that. So as businessmen moves outwards into, like what you said, countries that are developing where the rule of law may not be applied,
advanced.
So then you probably would want to look into this as a form of protection.
Yes.
Yeah.
And the other thing that we got to bear in mind here is SMEs, and their own is family-owned companies.
Yes.
Yeah, they're quite big.
Oh yeah. I mean, like Singapore right now, the government is encouraging, and I think we've managed to attract quite a fair bit of family offices. Okay, that's one of our firms, family offices.
Yes, private clients.
Yeah. So if you look at the family offices, the kind of money that they are investing out there, it's huge. It's huge. I mean, some of the MNCs may not have that kind of money. Very serious.
And of course, SMEs and private clients or family-owned companies, the decision-making process is much quicker.
Yes.
Because the boss is the boss.
Correct.
They can decide what to do, you see, and therefore they will be able to do it very quickly. So because of the quick process in making decision, and they may not want to take the compliance so strictly like how a MNC or listed company would do. And when a problem comes, and that's where the headache starts for them to resolve it. While multinationals may take a longer time, but they make sure to tick all the boxes.
They will have a checklist what to go through: tax, investment, compliance, and whatever. Yes.
So that's where I guess for private clients, i.e., family-owned SMEs, if you go to speak with specialists that handles the kind of work, they will know your sentiments better. In fact, I must highlight, Vidas is the world's leading private clients legal practice.
Yeah. We are one of the biggest.
They are known for their private clients.
Right.
So if you have lots of money, then you have a private client, like a private, privileged customer in the bank and all that. Yeah. So I guess these are the questions we have for today. and I don't intend to drag it. It's going to be 4:30 soon, and I guess we will get back to our routine after this, which is to work and it is Monday, so you can't take time off and party yet. So where we are, and we can't do work from home that much anymore now as well.
So next time I'll try to come on a Friday.
You try on a Friday, Thursday also. With that, thank you very much, friends, for joining us today for this special webinar. Winston, any final words to our Malaysian audience?
Well, I'm very happy that the borders have opened. So yeah, I'm looking forward to come here more often, and of course, all Malaysians are welcome to come to Singapore as well.
Sure. We are also waiting to visit.
I'm sure a lot of friends and relatives,
Yes.
We'd like to see each other. I've not seen him since pre-COVID.
Since 2019.
Yeah.
Yeah. So there we are. Okay, friends, thank you very much, and enjoy the rest of your afternoon. Bye-bye.